Welcome to Retire Coast, where we discuss all things retirement, life on the Mississippi Gulf Coast, and your financial welfare. Bill Anderson, your host, is a serial entrepreneur having created many successful businesses and holds a real estate broker's license, speaks about personal experiences with each topic. Listen, learn, and improve the quality of your life.
My friend and guest, Tal Braddock. He's an attorney at law in the state of Mississippi. He has been in the legal business for several decades now, and he's worked on cases all across the country, some very big ones, actually. And we're here to talk about the things that you need to do in your personal life. Now, before I start, I want to apologize for the sound quality. We have been talking recently about the need to help others that are in the process of deciding what to do with their wealth. And we're not necessarily talking about people who have millions and millions of dollars here. Actually, if you have a house, if you have a 401k plan, you have any type of assets whatsoever, you really should think about planning ahead. Now, this area is called elder law, and I'm going to let him talk about that in just a moment. And it's part of family law. And basically what we're talking about here is how you decide to create your estate planning portfolio, essentially, that includes a number of things, and I'm going to go over what those are real quickly here. One of them is a living trust, another one is a last will and testament, another one is instructions for transferring assets to the trust and how you do that, durable power of attorney for management of property and personal affairs, advanced health care directive, which most people forget about. They go out and get a will and they don't think about that, authorization and waiver for the inspection and disclosure of information related to mental or physical health, and that's if someone is failing in mental health and they need some help. Final disposition and authorization, that's, what happens. Do you want to be cremated? Do you want to be buried in a plot? All of that should be thought out in advance so that your heirs aren't dealing with that. So I'd like to introduce you now to Tal Braddock, and we're going to go through this list I talked about, and he's going to explain pretty much the major need for someone for each thing. We're going to start with living trust. So Tal, on a living trust, what is a living trust and what does that do for the people that have created it?
It's going to provide a lot of protection for your assets that you move into the trust. And it's a vehicle that's used by estate planning gurus and professionals to
move your house, for example. You would
right. Yes, sir.
You would quit claim the house into the
trust,
right? And so now the trust is essentially like a person, right? Under law.
Oh, true. Yes, sir.
It's
treated like that.
Treated like that. So then and you should discuss this with your family members also, so that they all know what you're going to be doing with that trust. But the main purpose of the trust is to avoid probate.
Avoid probate for sure. Yes, sir.
And then, so what does probate cause?
Oh my gosh! Yeah, I mean, it's just you bring out a whole, a whole genre, menagerie.
So if they have to go to probate, that means that they're going to have to hire
attorneys, and possibly accountants and other people.
And then pay other people to take a look at everything there, right? To
evaluate. Everything gets,
Yeah, and then, so what happens in probate? It goes to court, right?
That's correct, yes, sir. Now, in Mississippi, we have what's called chancery court, so that's where you're going to have, we have circuit and chancery, but that's going to be, the probate's going to be in chancery court.
So the difference between having a trust and not having a trust is if you have a trust, you make the decisions. If you don't have a trust, then some strange judge you don't know makes them, right?
That's true.
Yeah. And then there are tax consequences for any value, any monetary value that's transferred to others occurs with a simple a last will, right?
True. Yes, sir.
And the trust, there's no tax consequences to the trust. And now there's a lot of people wonder what's the difference between a trust and a will, because we're going to get into the will here.
Okay.
So the will is pretty simple. The will just says, I want Susie to get this thing, okay? But nothing happens with a will until you're gone, right?
That's true. Yeah.
Yeah.
Then you start to probate it, and then
Right.
Yeah.
But with a trust, you can do all this while you're alive, right?
Yeah,
Yeah.
and you sort of see what's going on prior to what happens.
So it's a revocable trust, which means you can make changes to it, and whoever is creating the trust basically runs the trust essentially when you're still alive, right?
Mm-hmm.
And then who takes over after you pass away?
Well, it's in the trust agreement.
Yeah, trustee, right?
Mm-hmm.
Yeah. So go ahead.
Yeah, well, the trustee doesn't really take over. They just provide guidance on where to deliver the assets to, and I guess any liabilities if you want to do the same thing, because you can have assets and liabilities in your trust.
And then some trusts, I mean, no two trusts are really the same. They may look that way on kind of a boilerplate basis, but I have an example I'll throw out there of a family member that inherited money from her father, and she was young at the time he passed away. So he was concerned that she would not be emotionally or psychologically ready to handle the assets, which were considerable. So he set up the trust long before he passed away, and directed the trustee, which was a friend of his, to only give her some rental money, just the bare amount that she could get by on from rental properties, and then she can't get the rest of it until she's 45 years old, which means that the trustee has a long relationship with the recipients of the trust. It's not just we'll sort this out and we'll pass out the money and that type of thing, because that's what happens with the will. The trust could go on for years and years, right?
True.
Yeah. So, and then so would you recommend that they have a will and a trust?
Oh, you got to have a will, and then I'd put the trust in there too. I mean, why not? I mean, let's go on and do it right. Do it right.
And because maybe there's something that they want to distribute later on, for example. So if they read the will and pass along whatever it is, there may be something in the trust that says, no, we're not going to issue that money right now. We're going to issue it in 5 years or something like that. So the trust would hold that money for that period of time. Whereas with a will, there's really nobody holding any of that. There's no trustee on the will situation, right?
No trustee on the will.
Right. Just somebody you've appointed.
Is what you're trying to implement here is to put in play a trust. I put all your assets.
Yeah, you put your assets in the trust while you're living, right?
True. Yeah.
Right, while you're living, and then the will becomes effective when you die, but the will and the trust can work together.
Of course.
Yeah, and the trust protects some people that you want to see get some money down the road, but you don't want to pay taxes because they will become an owner of that. A good example is in California, for example. California's property taxes are fairly high, and they had a bill called Prop 13 that was issued decades and decades ago.
I remember that. Yeah.
Yeah, and it locked in the rate at the time, right? So, if you had a house that at that time was worth $100,000, and now it's worth $1 million, if you're still alive, you're going to pay that rate at that Prop 13 rate at $100,000, whatever that was, and it might be $500 a year. Now, if you had that house in a trust, put it in a trust under certain portions of the law, that the people benefiting from the trust who will end up owning that house because the house is in the trust will still be paying that $500 a year, right?
Right.
Yeah,
Right.
because it never got sold. It was never transferred. And that is a major reason to create a trust. And there's probably similar issues all around the country where you can save your family lots and lots of money by planning ahead and doing this in a trust, correct?
Yes, sir.
And then you create the will also along with the trust because they serve slightly different purposes, right?
Correct. Yeah.
Now, how simple is the will?
Yeah. The will, you need 2 witnesses and then 1 notary. It's pretty easy. Sure.
Pretty easy.
Yeah.
So if they decide to go to an attorney, what should they do ahead of time? How do they prepare to go and see you, for example? If somebody comes to you and says, "I want a will," you have questions, right?
Oh yeah. We'll just take them through a walkthrough, just a random battery of questions.
On who's what, who are you, for example, and
Yeah.
what do you want to give away? What do you own? What are your assets? All those kinds of things, right? So if someone wants to create a will or a trust, they need to do some work ahead of time, right? They need to make a list of all their assets, right? The things that they want to give away, and they should be thinking about who they want to give it to, right?
Yeah, because the trust will define, tell you you can put it in there who you want to give everything to.
And the same thing with a will.
Same
also,
with the will, yeah.
right. So
You just added 1 layer of protection though, and plus you take it out of the hands of the courtroom, out of the hands, and let you distribute the money. Let the trustee distribute the money.
correct, but to form that, they need to do some thinking first. So they basically could contact their attorney, and the attorney will probably send to them a list of things that they need in order to help them, right?
True. Yes,
All
sir.
this information we talked about, they have to gather, and some people may not have thought about that. They go, "Oh, wait a minute, okay." And also, what about your relatives? What about your children and your grandchildren? Where do they fit in this? Shouldn't they be addressed somehow? Let me ask you a question. I had heard, and maybe this is just urban legend, that that if you leave a family member out of a will, for example, that person might be able to contest it, but if you give them $1,
Oh yeah.
is there any truth to that?
There is some truth to that, and especially sometimes you just want to give people $10 or $1 or something like that, just to make sure they know that's all they're going to get.
Right.
Yeah.
So basically, when they create this list, they should put all of their closest relatives on that list, right? And then designate what they get, if anything, so that they've been given consideration, correct?
That's it. Consideration.
Yeah.
Good. That's it. Good
Right.
term.
So even if they don't get any money, even if they don't get $10, they were listed and they're considered. Well, I want to jump to the other items on our list in creating a comprehensive portfolio for you that covers all of the things that are necessary. And we've already talked about the living trust. We could go on and on about this and get into non-revocable, but we can discuss these things individually in its own podcast in the future. We'll get more into living trusts. We'll get more into the last will and testament, but I want to move on to some other things. One of the items that should be part of the package is a durable power of attorney for management of property and personal affairs. Would you explain pretty much what that document does? And just explain it.
The power of attorney allows the trustee, gives them authority to act on your behalf.
So you basically appoint what your spouse would be the logical thing, right? If you have a living spouse.
True. Yes,
Yeah.
sir.
Yeah. Go ahead.
Yeah. Appoint your spouse, and then have designate her or him as the agent.
And then then you would have the others there too, other family members as alternate agents.
That's it.
Yeah, so if you have a son or daughter, you'd make them the alternate agents. And this would be a situation where, when would a power of attorney be used?
When, like, say a person goes into the hospital and maybe get to a coma or something like that, and it hadn't died, but the person's still alive.
They can't make decisions for themselves.
That's correct. Yeah.
Right. So this is pretty important to do when the person is alert and aware.
Yeah, they call it a lucid moment.
Right. Well, yeah, when this whole package is created, when just like you and I are talking today, and I would say, hey, Tal, why don't you create a durable power of attorney for yourself now while you are in good health and you are of sound mind, as they say in the legal business, right? Yeah.
That's it, yeah.
Yeah. So that's when you create it. So that way you're not trying to, force somebody who's coming in and out of, consciousness in a hospital bed to sign one of these. Right?
That's true, yeah. So
and
we already have it done.
Yeah, we already had it done. And there have been cases where those hospital bed signatures were contested, right?
Of course, yes, sir.
Because they were saying that the person really didn't know what they were signing. And maybe they were wealthy, and then the money just disappeared because of that. So that durable power of attorney is pretty important, that you have a trusted person manage your assets when you're not able to do it yourself, right?
That's it.
I mean, it might be you're not even in a coma. It might be you go in for an operation and you are, out of it for a day or two or something, where you can't make decisions because you're on drugs or something like that, correct? So it may be just a temporary situation. But so that's an important part, right, of the whole estate planning package.
Oh, of course, yeah, and it's something that goes right there with the will and the trust. I mean, durable power of attorney, boom, you got to get one done.
But each spouse, right?
True.
Right. So
each spouse.
Right. And by the way, one thing I'd forgotten. Sometimes we work with these things. We assume everybody knows. When you create the durable power of attorney, as Tal just mentioned, both spouses have to do their own. And then the same thing with a will. You need two wills. If you have a husband and wife, for example,
true,
you need two wills, right? It's not just one. And with the trust, you can have a single trust, but you'll have to have both spouses sign on that trust if they have joint property that's being considered, correct? So, but most other things we're going to talk about, you're going to need to have one for each individual. That just tells courts that they both know what they're doing, right? So that's the durable power of attorney. The next thing is the Advanced Healthcare Directive. And by the way, the power of attorney is different from state to state, a little bit different. The concepts are the same, but each state has its own probate codes or its own legal codes regarding what type of wording has to be in the document to make it effective. Because what happens if you have to go to court?
Yeah, you'd want to do it right up front, and whatever state you're in, it's no big deal. All you got to do is just look up the code section for that
right.
particular
and
state.
That's what the attorney already knows that in that particular state. So,
right.
But if you create one, let me ask you a question, Tal. Let's say I create a durable power of attorney when I am a resident of one state, and then I decide to move and I'm a resident of another state. Should I redo that in the new state with an attorney, or would the original work?
I think the original would work, but come on, what we're doing here is planning for the unexpected. So whatever state you do move to, you may want to get that particular code section and do an amendment or addendum to it.
Right. So basically, these people that are moving from maybe they were working full-time someplace, had a career, and they decided to retire. But before they did, they had all this work done, they had all their estate planning done, and then they moved to another state, like Mississippi, for example. Wouldn't it be prudent for them to go to an attorney and have their entire package reviewed for compliance with their new state?
Obviously, yeah, good idea for sure.
Yeah, that just, I think that might be a good thing to do. So maybe you've done all this work already.
That's just part, dotting I's and crossing T's.
Correct. It could just be a simple thing that you overlooked that your attorney can find for you and say, oh, this doesn't work here in Mississippi. Maybe it worked in California, it doesn't work in Mississippi. It's worth looking it over. So back to the Advanced Healthcare Directive, as I started to a minute ago. Essentially, that is what happens to you physically, right? When let's say you're in the hospital and you can't make a decision about your own health care. You have created that document that says what?
It's got, whether to pull the plug, whether not to pull the plug, whether to keep you alive.
Yeah, and that's a major thing. If you haven't left that and you are incapacitated in the hospital and your family is just stressed out because they don't know what to do, you never created an advanced healthcare directive, then you're going to have to go back to something. Hopefully you have the durable power of attorney, it might help. But they want to know what you want to do. That's what the Advanced Healthcare Directive is. Those are your feelings, your beliefs that you want to, take care of you. And it makes it easier on the family if you do this in advance, right?
Yes, sir.
Yeah. So that's why you should have that document created along with all of the others. And then we've got a final disposition and authorization. So that's what happens to you when you pass away. And my sister was telling me about a program that she was into. There's so many of them out there, with a company that says that she can pay in advance for having her cremated, and the service, all that was all paid for well in advance. In fact, she paid for hers 20 years ago, and she's still around, but she paid a fixed amount, and it's good for that entire time. So you might want to consider, as part of that, if you have the money, pay for it so that your children or your grandchildren aren't burdened with that debt. Now, there are a lot of other aspects to the estate planning, and one of those, I'm going to back up a little bit into the trust, and we'll get more into details, but this is all about gathering the right information and making sure that no matter which one of these documents have to be prepared, you have all of the correct information for those documents. The trust and the will require more information than others, but you need to give consideration to your survivors, right? To who's going to do what. Just as we talked about in the durable power of attorney, where you have your husband or your wife make a decision, then you also have alternates. First alternate, second alternate, third alternate.
And those alternates can be they can come in handy because you're talking 20 years ago. And the people that you trusted 20 years ago may be different than the people you trust today.
Correct. And then, getting back to the talking about having these documents reviewed, if there are major changes in your life or to your assets, if you sold properties, for example, or some of the people that you put into your documents have passed away, you need replacements for those. And that's another good reason to periodically have your attorney take a look at your document package when you know that there have been some changes, and sometimes significant changes to those.
For a number of years, so it's pretty interesting, the elder law part. So I look forward to working with you.
Well, thank you. So please come back to Retire Coast. podcast and go to our website, retirecoast.com, where we have lots of articles in there about the similar topics that we talk about on our podcast, and you can see a lot more detail in there. So please come back, listen to our podcast in the future. Thank you.